How do you transfer a car after a person's death in Arizona? Hi, I'm Attorney Paul Deloughery, and we're going to talk about 6 different common scenarios, okay? So the first 2 have to do with when the car is owned in the deceased person's name alone. Okay, so first of all, you need to figure out, was there a will or was there not a will? If there's a will, then you should follow the terms of the will. If there is not a will, then you go under the laws of intestacy, which are set out by the statute. And there are also issues about whether there are more creditors or more debts than assets. That's a whole different scenario. I'm going to assume that I'm going to assume for purposes of this that there are more assets than debts, and someone is entitled to the car after someone's death. Okay, so first two scenarios that cover when the car is owned in the deceased person's name. So, number 1, if the value of the car is less than the statutory amount in Arizona for transferring assets without a probate, and actually, let me clarify, if the value of all personal property is less than the amount set out in the statute, currently that's $75,000. So assuming bank accounts, personal property, artwork, collectibles, coins, the car, other vehicles, everything added up is worth less than $75,000, then there is a small estate affidavit that's available, and it's on the Arizona Motor Vehicle Division website. And so a person or persons can sign that affidavit and transfer the vehicle. Now you have to do it. You have to transfer it to the people entitled to the vehicle. It can't just be first come, first serve. Whoever races to the Motor Vehicle Division first gets the car. That's improper. It has to be whoever's entitled to it. So if there's, let's say, and there's a lot of different situations here. I'm going to cover common ones. Let's say there's a surviving spouse, no kids. The surviving spouse under the statute then is entitled to the car, assuming that a will doesn't say otherwise. So the surviving spouse then can sign this affidavit and transfer the car. If there's a surviving spouse and stepkids, like 5 stepkids, then the surviving spouse and the 5 stepkids can transfer it to all of them. It sounds like chaos, but theoretically that's possible. They can all work together. I've actually never seen that happen, but I don't want to jinx you. So you could do that. Again, assuming that the will doesn't say something other than that. If the value of the property is worth of all the personal property, again, artwork, coins, accounts, whatever, without beneficiary designations, if the value of all of that and the cars is worth more than $75,000, then someone needs to do a probate. Again, look for a will. The will should nominate someone to serve as personal representative or executor. Could use, in Arizona we say personal representative. So that's possible. You may have to just do a probate. The whole different situation. I'll cover that in some other videos. But okay, so we covered the first 2. The car was in the deceased person's name alone, and it was either all the personal property was worth less than $75,000, and everyone entitled to the car is willing to sign this affidavit, willing to work together, or they're not willing to work together, and the value of all the personal property is worth more than $75,000. Okay, in which case, the second scenario, you just have to do a probate. Okay, first 2, we have 4 more. Okay, second one, the Motor Vehicle Division also has a form now called a beneficiary designation form. So you might just check and see if the deceased person had a beneficiary designated for the vehicle. So that should be on the title. If you have a question, you can go to one of the title places here in Arizona. There are lots of different little title transfer businesses, or you can go to an official motor vehicle division location and they'll be able to answer that for you. Okay, so that's 3. Number 4, on the title, actually 4, 5, 6, okay? So on the title, it might say Betty Jones or John Smith, okay? Betty Jones or John Smith. It could say Betty Jones and John Smith, or it could say Betty Jones and or John Smith, okay? So let's cover those 3 different scenarios. Or, and or. Okay, or. If it says the deceased person or someone, then the other person can just sell the vehicle, okay? So either one can sign. So if one of the persons dies, then the other person can transfer the vehicle, sell it, whatever. And if it says deceased person and someone else, then both of them need to sign. And then we actually go back up to the first 2 situations, or I guess it could be the 3rd situation. So if it says and the deceased and one of them died, then either it's worth less than $75,000 and all the people entitled to receive the car are willing to sign off, or not everyone's willing to sign off, or all the personal property is worth more than $75,000, in which you need to do a probate. And I guess theoretically, if you have a deceased person and someone else, the deceased person could have done a beneficiary designation for their interest in the car. I guess that's possible. Okay, last situation, and or. And or is a little tricky. It actually means either one. So in that situation, okay, the next situation, or the last situation, is and or. Now with and or, what you need to do, the other person needs to present a death certificate, and then they're able to transfer the car. So and or basically means or, okay? Okay. Now scenario number 6, and or. If it says and or, then the surviving owner simply needs to present a death certificate, and then they can sign to transfer the car or sell it or whatever, okay? So and or really means or. I'm not sure. I think a lot of people are indecisive and don't really know what to say, but and or is interpreted as or. So either one can sign. And let me actually go back and explain the other situation. So if the title says and or and or, in those, the last 3 scenarios that we talked about, the surviving owner needs to present a death certificate. Now, the tricky part with that might be if the surviving owner is not a family member and is not entitled to receive a death certificate. Well, that can get a little tricky. We can help you with that. There's a lot of little nuances here that we didn't cover, but I did cover the 6 most common scenarios. So hopefully that helped. If you have any questions, reach out. Our phone number is 602-443-4888. Again, my name is Attorney Paul Deloughery.